Are there allegations of mismanagement of funds within your partnership firm? Are there allegations that one partner has exclusively used the turnover and the assets of the firm for himself or his family members or for his own companies and so on? In such a situation, what do you do? That is going to be the topic for today's video. Hi everyone, my name is Ramana Reddy and I am a practicing lawyer in the High Court of Telangana. On this channel, I help you by simplifying complex legal concepts. For tips, tricks and general legal information, make sure you hit the subscribe button below. So the three most important things in any partnership dispute are accounts, accounts and accounts. That is literally the most important thing when you are going into a partnership dispute, because most likely the allegation is that one partner has diverted the profits of the firm, the turnover of the firm, or has somehow mismanaged the funds in the firm, or that he has used the firm's factories or the firm's assets for his own personal use and so on and so forth. So in such a situation, the accounts of the firm become extremely important because money leaves a trail. So, you cannot go into a fight with, for a partnership dispute without being armed with the accounts. Now, I understand that in some situations, you may not have the accounts and you may have to get the accounts from the opposite party and you may have to file some applications like, it's called a notice to produce under Order 12 Rule 8 of the Civil Procedure Code. And, you may have to do these things. But going in, you must understand that one of the most important things or one of the most important tools in any partnership dispute for both parties will be the accounts, because numbers don't lie. So when you are looking at accounts, you have a team of three people. You have the lawyer, someone like me who is assisting you on the legal side of things. Then you have yourself, the client, who has lived through the entire situation and he knows the facts best. He knows what happened at what time. And the third actor in this partnership dispute is going to be your chartered accountant. You will need a very good chartered accountant who will be able to dig out information and make out and help your lawyer make out a case. If you just go in, if just two people go in, the lawyer and the client, you are not going to be as effective as if you had gone in with a chartered accountant who will look at the accounts and who can clean things up for you. So it is extremely important that you have the accounts with you before you go in and you start fighting a partnership dispute. Now the next thing to see is when you have to pull up the partnership deed and you need to see whether there is an arbitration clause in the partnership deed, because whether you go to the local civil court or whether you go to an arbitrator, that is going to be determined by the clauses in your partnership deed. And those clauses will be important, to see which forum you need to go to. Now, if there is an arbitration clause, then in such a situation, what do you do and what is the basic procedure for arbitration? Click on the links above where I talk in detail about that and you can find out what the arbitration process is. So basically you need to look over your partnership deed to see if you have to go to civil court or you have to go to an arbitrator. The next thing that you will have to look at is what is the type of partnership. And there are different types of partnerships under the Indian Partnership Act, and you'll have to look at, so the most common one that is used, which according to me is the worst business entity that people use, is something called a partnership at will. So you'll have to go back and look at your partnership deed to see whether, if it's a partnership at will or whether it is a partnership that is there for a particular purpose, or if there's a limited time for which the partnership is to exist and so on. Now, in a partnership at will, the reason why I say it is the worst is because let's take an example. Let's say that there are 5 partners. Now, it is okay, one partner can retire and, the partners can come and go. But under a partnership at will, any of these 5 partners who has a problem with the other partners, he can just dissolve the entire partnership and bring the entire partnership to a standstill. Not just a standstill, but just dissolve it. I mean, I can understand if one partner wants to retire, that is one thing. But to be able to dissolve the entire partnership, just to close shop basically, because one partner has some problem with another partner or has some issue with funds. I mean, that is a very powerful tool for somebody who wants to arm twist the other partners, which I have seen frequently, being used by any partner who's aggrieved. So you need to go back and you need to look at your partnership deed. Is it a partnership at will? Now, if you are the one who has a problem with the other partner, you could use that to your advantage. You can issue a notice to dissolve the entire partnership if you want. So that is another thing that you'll have to look at. Another frequently used common arm twisting tactic is that, if I'm a partner and I have a problem with another partner, or if I have doubts that money is being misutilized, what I will do is I will write to the bank and I will say, look, there are partnership disputes between us, so just freeze all our bank accounts. And that also I have seen as a tactic that is being used to bring the firm to a standstill and bring all the partners to the negotiating table. Now, keep in mind that such freezing is not legal. There's a case called Modern Metals by the Allahabad High Court where they've categorically said that you cannot bring the firm to a standstill. But the practical reality is a lot of partners use that as a tool to freeze bank accounts, because the banker is not going to take a chance, because it's his money that that he is lending to a business, and he will not take a chance. Partners who have problems with other partners take advantage of that fact, and they write to the bank to freeze bank accounts. In such a situation, the other partners have to approach a court of law, and they need to get they'll make the banker also a party to the to the case that they file, and they will try to get the account unfreezed. Another issue that I commonly see is, in case, say, there are, two partners, one partner has left, another partner has joined. The partner who has left is, he has taken a settlement and he has moved on. But later he finds out that, all the accounts were not shown to me, that there are things in there that, that were hidden from me, or basically a fraud was played upon me, or there are substantial errors in my settlement account. In that situation, again, it is going to be an uphill battle to be able to go back and reopen settlements, but it can be done. Where you have taken a settlement and yet the problem is that you have not completely looked over the accounts, or the accounts that were furnished to you were incomplete. In that situation also, you can go back and reopen the accounting process. Just know that it will be an uphill battle, because the burden of proof will be heavily on you to show that there was some fraud or that there were substantial errors in the accounting process. I hope that video was helpful. Thank you for watching.